SJC-13157, Commonwealth v. Concetto S. Costa.
Okay, Attorney Levin.
Thank you, Your Honor. Good morning. May it please the Court, Patrick Levin on behalf of Concetto Costa, who appeals this morning from the revocation of his probation based on an uncorroborated hearsay accusation that he was not permitted to challenge in any manner. There are three parts to my argument in this case, each of which the Court really only needs to reach if it disagrees with me on the prior argument. So they do bleed into each other a little bit. I'm going to try to keep them analytically distinct. The first issue is the admissibility of the hearsay absent confrontation in the Commonwealth's case in chief. The second issue is if that was admissible, whether Mr. Costa was properly forbidden from summoning his accuser to be cross-examined in his case. And then the third issue is if it was correct for cross-examination to be entirely denied, whether it also was proper to forbid him from calling other witnesses to impeach this accuser's credibility. So as to the first issue, I just want to emphasize that we have never claimed that this hearsay does not appear reliable on its face, and that in the absence of the evidence developed through the defense investigation certainly would have been admissible. And for that matter, that also is true of my second claim, that in the absence of the defense evidence, he also properly could have been precluded from calling this alleged victim as a witness in his own case. The key to this case is the evidence that was developed by the defense suggesting that this person's account was not to be trusted. And the motion judge first, Judge Howe, improperly disregarded all of that defense evidence when she was deciding both whether the hearsay was going to be admissible and whether Mr. Costa would be allowed to summons the accuser himself. And her reasons for doing so were legal error, and they also were not really pertinent to the issue that was before her. I want to draw the Court's attention in particular to the motion judge's statement that the defense evidence appeared to be a veiled attempt to show that this witness had a propensity for untruthfulness. This was not a veiled attempt. It was a forthright attempt to show that this accuser was not an honest person and that her word could not be trusted in the absence of cross-examination.
Mr. Levin, you're certainly correct that these three issues bleed into each other.
Yes.
And just demonstrated with that argument. But let's go back to the first one. Isn't there a level of complexity in our case law that we need to grapple with your argument, in the sense that the issue is not whether or not the hearsay was admissible at the probation violation hearing. The issue is under Durling whether it had substantial reliability, and again, to use your phrase, I think you're right, because it's very hard to compartmentalize these three arguments. That then flows into your second and third argument. I mean, that's sort of a conceptual framework we have to grapple with, isn't it?
I agree, Your Honor. But what I would say is the question of whether the hearsay has substantial reliability can't be made in total disregard of the suggestion that the person who's making the accusations is not a credible witness. And so as you see this in the appeals court's opinion in Commonwealth versus King, which is cited throughout my brief, where the court says so the police respond in that case to an alleged domestic incident, and they see, I mean, the alleged victim says he kicked in the door and, broke down the door and assaulted me, essentially, and the police observe the door is broken down. But they also observe some reasons within this person's demeanor and conduct, as well as some prior incidents, apparently, where she had been found maybe not to have been telling the truth to police. And in light of those other pieces, the appeals court says, well, were it not for this, then we might find the hearsay reliable, but this other information so undermines the reliability that we can't say that this is substantially reliable hearsay that justifies the revocation of probation. And I want to emphasize also that This is a pretty unusual case. I've dealt with a number of these cases, and it's rare to see this type of robust showing of dishonesty on the part of a complaining witness. And not, I mean, certainly dishonesty as a general matter, including these false accusations that she's made in the past, the pattern of lies and theft that her exes describe, but also this evidence from the disinterested neighbors that is not consistent with the story that she tells about Mr. Costa. And so I don't think that this court's decision in this case sweeps very far beyond this case. It's pretty unusual to see this type of a showing. And I want to emphasize also—
Would that be true if there were any marks on her? I mean, if she had any indication of bruising, or she's, the slapping, what we see in a lot of these cases, would this all go out the window if that were the case? Because we've got a lot of people who lie in a lot of things in the world, but we don't sort of, develop that evidence like that. We don't. I mean, you say there aren't many cases out there. It's because we do it through reputation, right? We don't allow individual instances to be proven. So I'm just trying to understand the limitations of this, because I see each one sort of, mushrooming into problems.
Yes, Your Honor. So to take your latter point first, I agree that type of information typically doesn't get developed at trial. But even in my experience looking at defense investigations, you don't that often see this type of allegation of a consistent pattern of deception, including false accusations of crimes. But to go back to your initial question—
I see the point about false accusations of crimes, but we see a lot of questioning everyone's factual statements and shading of truth and that kind of stuff.
That's right. And I do want to emphasize that Judge Howe on this motion was not deciding whether what any of these people were saying was true. She was deciding whether at the hearing it would be necessary for that story to be told in person and subject to cross-examination, which is the way that our system typically sorts these things out.
I mean, I get the significance of the fact that she may be bipolar. I get the significance that she may have made up criminal activity. The fact that her neighbors think she's obnoxious, a lot of people's neighbors think their neighbor is obnoxious. I mean,
Well,
we're not going to really open that up each time, are we?
Yeah, I agree that the fact that—
and that their ex-boyfriends think they're shifty and untrustworthy. That's also going to sweep in a lot of bad relationships, isn't it?
Well, yes, but so to take both of those points, first, as to the neighbors, I agree. It's not particularly relevant that they find her obnoxious. But the point is, the neighbors didn't say, "We never heard anything. We didn't see any problems in this relationship." What they said is, the walls in this apartment building are incredibly thin. We did hear them fighting all the time, and it was always her screaming at him. She was always the aggressor. And if you take her accusations as true, it's hard to imagine that at least one of these neighbors wouldn't have heard at least one of the occasions, the dozens, all weekly, multiple times a week, she's alleging over the course of 4 months, that they're having these fights where he's the aggressor, screaming threats to kill her, forcibly preventing her from leaving the apartment.
What is the defendant's relationship to the ownership of this complex?
There's no relationship apparent on the record, at least. His mother had previously lived in the apartment building before, so that's how he met the alleged victim in this case, as she was his mother's neighbor. And then he moves into the apartment when they become engaged.
So the neighbors know the mother, presumably?
Presumably the neighbors know the mother as well, yes. But then to go, I want to get back to the question that you originally asked me. I do think we have a pretty different case if there's evidence of physical injury to this victim.
So if we're going to compartmentalize your holding, where there's actual physical corroboration of anything, we're not going to require this. What you're saying is we could limit yours by saying, okay, we're in a case in which we have absolutely no corroboration except for the consistency of the statements. Then, it's a he said, she said, and you got to put the person on the stand. And is that consistent with, the cases out there? I understand there's very little, but Hartfield is your best case.
Yes, I agree.
Is there anything else out there that's helpful on that point?
So Hartfield is essentially the only case on this question of when the due process right to present a defense requires that you be allowed to call your accuser.
Right. I'm just looking for a workable rule.
Yeah, well, I do think this is an area where bright line rules are not appropriate. The due process test is a fact-specific totality of the circumstances balancing test. And so you have to identify all of the interests in the case, look at it on your particular facts, and make an ultimate determination. And when you think about the interests in this case, it is important, I think, to remember that the probation that's being revoked is on a life felony. And so if the court were to say the process that was given here was adequate, it would be saying the process that was given here was adequate for life imprisonment. And in fact, the Commonwealth did request a sentence of 18 to 20 years in the state prison after the revocation in this case. And so when you're talking about balancing interests, the liberty interest at stake for Mr. Costa here is immense. And
Is your argument based on the confrontation clause, or is it the right to defense?
it's not a confrontation clause argument because the confrontation clause does not apply to this proceeding. But the right to due process of law does provide a limited right to confrontation at probation revocation proceedings.
Why do you say the confrontation right doesn't apply?
That is based on the Supreme Court's holdings in Morrissey and Gagnon.
I thought those cases listed some limited due process issues, and one of them was the right to confront.
That's right, but the right to confrontation at this hearing is grounded on the right to due process of law in the 14th Amendment and the right, the parallel right in Article 12 of the Declaration of Rights, not on the specific Sixth Amendment confrontation clause.
You also said the intensity of the violence, so the fact that he's going back for a long prison sentence, we'd have a different standard if it's 3 months left?
So it's the same standard, but the interests that are balanced in that standard are different.
Have we
If you
done that?
see-
Have we done that, Mr. Levin? There's a liberty interest for sure, but have we done that as far as looking at the sentence that could be imposed?
So I think if you look at the opinion in Hartfield, it does specifically call out the consequence of revocation in that case being the imposition of a suspended 2.5-year sentence.
Because my memory is just we've said there's a liberty interest because you have the possibility of jail. We've never said there's a liberty interest because you have the possibility of a lot of jail.
Well, I don't think you can ignore when you're defining the defendant's interest. I don't think you can ignore specifically what.
No, I think that goes to what you've said before, that this has to be case by case.
I think that's right,
And
yes.
not bright line, because as you talk about false accusations, I'm obviously reminded of Bohannon, where we did give a bright line, but that's really not applicable here, because here we're dealing with substantial reliability at bottom, correct?
Yes, that's right. I do want to just touch on the third question regarding the admissibility of his proffered impeachment evidence. Just to really point out that when you're doing this balancing of interests, again, the Commonwealth's chief interests in excluding evidence at these hearings is not that it makes it more likely for a revocation to occur, because the Commonwealth only has an interest in revocation if the revocation is proper. And so the Commonwealth's chief interests are administrative efficiency. And these witnesses were present in the courtroom. These witnesses took the stand. It would not have have been a huge imposition to hear their evidence. And so when you're doing that balancing, I think that's pertinent as well.
I know this is in Magic Land, but were the witnesses allowed to testify? Would that be sufficient due process as opposed to subjecting the complaining witness to cross-examination?
So my answer to that is no. My view is that the Justice Englander in dissent in the appeals court was correct when he said that this is the case that the Supreme Court was talking about in Gagnon, when they said there may be some cases where you really need to have live testimony. If there are no more questions, I would request that the case be remanded for a new hearing where Mr. Costa can present his defense.
Okay, thank you very much.
Thank you.
Attorney Jansen.
Good morning, may it please the court. Catherine Jansen on behalf of the Commonwealth. My brother is absolutely correct that these issues definitely all kind of blend and meld in together. And I think what gets kind of lost a little bit is it's not necessarily just a right to confront his accuser, but also whether there's a right to present his defense. And going first on whether there's a right to confront his accuser, whether that issue rests on whether the hearsay admitted is substantially reliable or there's good cause under Durling to not call, to not have the accuser or the victim in this case come testify. I would just like to suggest that there absolutely was good cause here, and the Judge Howe found there was good cause separately and apart from finding substantial reliability of the her hearsay statements due to the affidavit from the prosecutor, which she credited that this was going to cause undue trauma to the victim, and this is the type of case that is exactly contemplated by this court.
But it's not a per se rule, correct? So for instance, you know, if there's a case that could involve potential victim or complaining witness testimony, the judge doesn't say, well, this is a victim case, the victim is not testifying. We have to look at the entirety of the record, which could include submissions by defense counsel. True?
Correct, Your Honor. I don't think saying this is a rape case or a victim case, you're not calling the victim, or the Commonwealth has to present the victim. I don't think that would be an appropriate rule. I think you have to look at, one, balancing the interests and societal interests of adding probation revocations as another thing that a victim, especially a victim of sexual assault, has to testify to, with in whether she's going to have, her testimony is going to aid the reliable determination whether a revocation happened. And I would say here, Judge Howe clearly did look at the evidence proffered by the probationer about whether or not, in substantial reliability and good cause, she found properly, I would submit to the court, that the evidence he submitted, which were investigator interviews of the neighbors and ex-boyfriends, were not substantially reliable. They weren't under oath, like the grand jury testimony, the restraining order affidavit by the victim, as well as they weren't made to a police officer, so there's no risk of a criminal charge from that, from lying to a police officer. And also to the fact that victims, the neighbors hearing the victim or not liking the victim don't necessarily directly contradict what the victim had said. And I would also submit, if you listen to the voicemails, I believe they were transmitted with the appeals court case. If not, I'd be happy to have that happen. But when you look at the tone and nature and tenor of the relationship through those voicemails, which corroborates the victim's account regarding the nature of the relationship, he's not very loud and screaming at her. They're very aggressive and menacing. And so she never said he threatened to kill her by screaming at her. He said he just threatened to kill her. And so you can definitely see where these threats and this violence that happened doesn't necessarily mean it's going to be loud and the neighbors are going to hear it.
That all may be true, but what concerns me here is it's hard enough to prove a negative, right? Because he's claiming that it didn't happen. So it's hard enough to do that just in general. But when you're not allowed to confront, and we know that the procedural guarantee of that is cross-examination, you can't cross-examine the complainant. You can't bring in your investigators witness, and I understand that you say there might be all kind of warts to these witnesses, but nevertheless, they're folks that were mined by the defense that were helpful to the defendant's position. And you have to also add that we know that the quantum of proof is just a preponderance of the evidence. Why wouldn't all of that militate in favor of giving the defendant some opportunity, some due process opportunity to defend himself?
I would suggest he was given that opportunity to defend himself.
How?
I think because, one, his statement from the restraining order hearing came in denying that this happened, saying she's making this up, she's using this to break up with me. He was able to get that in without having to testify himself and be subject to cross-examination. He also was able to get in he was given leeway through the revocation judge with the ex-husband's testimony regarding there could be a motive to fabricate this through the custody issues with her daughter, or access to that, as well as through the probation officer, that this could have been her relationship with the defendant could have been an impediment to that. He also was able to elicit from the landlord, who he called to testify, that there were no complaints from the neighbors. I saw no damage to the apartment like she had claimed. He was also able to highlight an inconsistent statement regarding the consensual sex that she had said that never had happened in the grand jury testimony versus said it did happen a few times with the police officer, as well as the fact that she never expressed any concern to anybody. So this was not a case where he wasn't able to present direct evidence directly about this relationship with her relationship with him. Anything with the ex-husband or ex-boyfriend, where I think the judge was correct to say that these are kind of collateral in nature and they're not really relevant about what this relationship is. And as far as confronting the victim and having her being called by the Commonwealth or him being able to present a defense, I think they're different. You can't just call.
Isn't the most useful information he can bring is direct testimony from someone else involved in a relationship with her, that she will use the criminal or legal process, misuse the criminal or legal process. I mean, otherwise, he's got no shot here without being able to at least put her on the stand, right? I mean, he can't defend himself, right?
Well, I would disagree that.
I mean, probation's gonna be revoked. You've got this, if she's telling the truth, and she's said the same story 3 times, he's saying she's bipolar, she's misused the system in the past. Give me a chance to show that. But he doesn't really get to do any of that. He gets to put in this kind of marginalia.
Well, I would suggest there was no actual evidence that she had actually misused the legal system in the past. There was nothing from his showing and proffer from the ex-husband that she actually did lie in the custody proceedings or followed through on those threats. And so I would suggest that claim is not reliable. And I would also suggest there's no showing.
Not reliable because it's not corroborated? Is that your position?
I would say it's not reliable because it's not corroborated. That is.
But on her and her grand jury testimony, it's substantially reliable, even if not corroborated. How do you reconcile the two positions?
I would say that her testimony was corroborated to an extent. I understand that the physical assaults and the rapes directly were not corroborated by physical evidence. However, I would say to use the case my brother used, King, her demeanor when talking to the police officer, consistently when being interviewed by the prosecutor, before the grand jury, that corroborates, I think, the nature also of these, of what she's saying happened. And I would also suggest the fact that the picture that he would send a picture of a gun in his mouth to her, the voicemails, I do think those corroborate more. That's more substance than what he was trying to get in through the ex-husband.
So your argument has dealt with whether the hearsay is substantially reliable. And also you've made the arguments why the alleged victim shouldn't have to testify. Don't you have to address the issue of the limitation on cross-examination separate from the victim in and of itself as well?
Yes, Your Honor. I think those are separate issues.
They bleed into each other, as Mr. Levin said, but you still have to straight up deal with the impeachment evidence that was proffered and not admitted.
Correct, Your Honor. And I would suggest that the goal at a revocation hearing is a reliable determination based on relevant evidence. I would suggest that the opinions, and there were two types of, I guess, evidence that was offered for impeachment: opinion, reputation evidence, and then also some specific instances, which the probation alleges were a pattern of conduct. As far as opinion evidence, that's one, not reliable. I think for the same reason that a reputation from too small a group of people is not reliable. And two, I also think it's not relevant based on these unique relationships that she had. Every relationship's different. You can't really say someone's going to act the same way in a relationship. And as far as pattern, I guess I would say pattern of conduct evidence is maybe the best way to frame it. I would suggest this was straight propensity evidence for the use, and it was sought to be used for the very reason why we don't use propensity evidence, which is she's lied in a claim, an unsupported claim that she's lied in the past and that she's going to do it again in this instance. And, you know, it would be improper for the Commonwealth to say, well, the probationer was on probation for rape of a child, so because he committed a rape before, he likely committed this rape. And that would be improper, and I think they kind of follow the same line. And I would suggest that the pattern here was not false accusations of this type of rape or this type of violence. And I think if it had been, we might be closer to a Bohannon issue where even if there wasn't independent verification, which I would suggest you probably would need something for the reliability aspect of it, but you'd be closer to that.
Well, I'm going to just probe that for a minute, because my understanding was that it was being offered for a non-propensity reason. Like, this was her pattern. This was the pattern of how she operated, and that's a non-propensity-based reason. So why wouldn't that have been appropriate evidence for the judge to consider on the revocation?
Right, I understand that the claim was that it wasn't propensity. I would suggest it was. However, as I had said before, I don't think this reaches the level of pattern of conduct, because for pattern of conduct, I think you need to have more similarities than just this. For example, oftentimes in cases we have somebody who has a deviant interest in young children, right? And that would be unique circumstance. I think here you have the ex-husband, there's custody issues, and that's kind of with her pattern of conduct with him, whereas with this ex-boyfriend, it's money issues. It's not the same type of allegations that are being made here, and I just don't think that they rise to that level.
What were the money issues? If you could, please, if you go, give me the specifics on
I believe the money issues from the ex-boyfriend were that he took out a loan for her and she didn't pay him back, and then she stole $200 from him. He claims that she had hit him on the side of the road in New Hampshire, but he pled guilty to that, suggesting that he actually did hit her. So I don't think it rises to the level of a pattern or conduct. I think they're unique relationships, and I would suggest it's not enough.
So as I understand the case law, the default is that the probationer can call witnesses.
Yes.
What is the factor that you're relying on in this case for not requiring or not allowing him to call her?
Well, I think it's a totality of the circumstances and
What are
of all
those?
three. So whether his countervailing interests overcome his presumptive right to call the victim or a witness, I think the number one factor, because there was a individualized showing of trauma to this victim, I'm not going to hide behind that and say that it is a big factor for the Commonwealth. And there was a strong showing that this would cause undue harm to the victim. I don't think that alone would be enough, most likely, to not call the victim to present a defense.
You're saying that was strong because there was an affidavit of the prosecutor saying that she, what?
Saying that she, every time when she first interviewed her, she was hyperventilating, she was crying, she felt like she was going to throw up. When she testified before the grand jury, she had to pause multiple times. She almost vomited multiple times in the grand jury and was crying.
Okay, so that's one factor. What, and the other two factors?
And so the other two factors are whether or not her testimony would add anything different from what was already presented. in terms of, I guess, the.
It's whether it would be significant in determining whether it's more likely than not that he committed this violation.
Correct, that's one of them, and when you're looking at that factor, you're looking at whether her testimony would be cumulative of other evidence, and I would suggest it would be. Here, there has to be some hope or some showing that you're actually gonna be able to elicit something from her, and I would suggest here, a showing that could be made by a defendant is, you can only get the motive to fabricate out of the victim, or there's a real hope of getting inconsistent statements out of her. Here, it doesn't.
No, I think a good cross-examiner would try to make her look less credible.
Well, I would suggest that that's conflating the right to confront and the right to present a defense. I don't think you can just call a victim.
They're different rights, but they do overlap.
They do overlap, but I think there has to be some hope of presenting some type of evidence, and that would be whether you can only get a motive to fabricate out of her prior inconsistent statements, which are definitely kind of close to the line of cross-examination, but you need to have some type of showing you're going to be able to get that out of her, and here, there was not that showing. I think it was speculative at best, and you get the motive to fabricate out of her ex-husband as well as the probation officer. So her testimony wouldn't have added anything, and I don't think.
Well, it's a chicken and the egg, right? Because she's not put on, we don't know whether any of that would have come out.
Well, I would suggest the questioning, the line of questioning he would want to go into would be improper for the same reasons why it was improper to ask the ex-husband and ex-boyfriend about that. And I would suggest this is not a case where he's made a showing where there's no number of inconsistent statements from her and you're hoping to get another one out of her, or there's only a motive to fabricate that you can get out of her. That's not this case.
Okay,
If there are no further questions, I'm happy to rest on my brief.
thank you so much.
Thank you.
We'll take our morning break.